Hello. Okay, welcome back to Aspire Education and our discussion with Joe McElroy over really broadly educating our children, as it says here, is an unalienable right. So understanding our rights, part 2 of our interview. And moving on from there, like we promised in the first one, Joe is going to walk through so that everyone can kind of understand some of the principles that we were talking about in the last portion and understand and apply it directly to this Homeschool Act that has been introduced here in Illinois, HB 2827. Okay. I don't think I'll ever forget that number. What about you? I think we've had to say it. So Joe, I'm so glad to have you back. And let's just jump in here because we're going to be talking about, again, we're going to bring you back to the foundational principles here and understanding that educating our children is an unalienable right, which means it is God-given. It is our right. We do not relinquish those rights ever, right? Ever. But we are in the process of understanding and working towards, right, Joe, asserting those rights within this system that is, everybody knows, is incredibly broken, right? So let's jump in here and talk about this principle again to kind of segue here. And I believe, Joe, this one you brought in from Vermont's Constitution, yes?
Yep.
Okay, go ahead and tell us why.
To remind everybody, we gotta follow that conversation and order it right. And so we're starting with biblical principle, then go to the maxims of law, then go to Constitution, and then ultimately you have the statute. And brought this one in here. This is a provision out of the Vermont Constitution. But remember, all of our states are supposed to be Republican in form. So while there's provisions that in other parts of the Constitution that will deviate from state to state on what they're doing and how they're outworking something, one thing to keep in mind is that the Bill of Rights in every state constitution, in different states, they express or assert those rights with different words that we don't necessarily have in our Illinois Constitution. So this is a provision from the Bill of Rights in Vermont. It's Article 6. And it's establishing the fact that all power being originally inherent and consequently derived from the people. Therefore, all officers of government, whether legislative or executive, are their trustees and servants, and at all times in a legal way accountable to them. And that's just a principle to get in people's mind to establish that, number one, the people have all power. Number two, we are the source of power, and all the power of government derives from the people. Number three, officers of government are our trustees and servants. Remember, the people are the masters, and we've delegated some of the power to them. And then the very last part of this is very interesting because people think that we can only assert our power at the ballot box every 2 or 4 years.
Exactly.
When that's not true. The truth is we can assert our power at all times in a legal way. And that's why understanding the difference between like what we're doing with a notice versus making the phone call to your legislator. I'm not saying to not call your legislator. That's not a bad thing to let them know your opinion on something. But when we write it down on paper and give them a formal, lawful notice, there's a different impact, and it's holding them accountable in a legal way, not just expressing our support or opinion on a matter.
Right. In a lawful way. In other words, going back to common law, it's the same thing we talked about last time, right? This notice, the words that everybody's used to, especially us recovering lawyers or practicing lawyers, right, is very much like a complaint, right? It's a notice, just like we talked about in the first section, the first portion of this, part 1. Yeah. And so
to run ahead real quick, you're going to see how in the statute, they have to give us notice about stuff.
Correct.
Well, we're using the same tactic, the same form of law, the same process to send them notice ahead of time.
Exactly. It's the same thing as if your neighbors, knock down your fence accidentally and you're not happy about it. So you let them know and say, hey, realize accidents happen. I need you to fix my fence. And they say, no. Okay. Right. And then you're going to put them on notice and you're going to let them know, in a formal way. Right. And that way there's accountability because they know. Okay.
Yeah,
so
I can't get past the biblical principle of it because
Yes.
God spoke and he created everything, but then he wrote things down in his book called the Bible that are law. And the same way we follow the same pattern that God does. We are the creators of our government. So we have the responsibility to write down things to make sure that they get carried out, which is why we have a written constitution and so on and so.
Right. Yes. And that principle didn't even come around right away. Right.
Mhm.
Okay. Excellent. Yes. And that's very true. And honestly, if you think about it, it also is the same principle that God lays out for us in Matthew when you have an issue with someone.
Yep.
You go to them and you speak it, just like with your neighbor. The first thing you do is you talk to them. There's notice. I'm not happy. This is why, right? And then you're trying to work it out, right? So you start there, same thing, principle, right? And if that doesn't go well, you ask for another person to come and listen and be a part of the conversation if that's not going well.
That's all common law.
Exactly. That's to your point, right? It's biblical first, and then it's just carrying that out. It's the exact same process, right? That God lays out for us. So I love that. I'm so glad you brought us back to that again, Joe. Okay, so now here's the first screen. So what you're going to see as we go through these, and mostly Joe, I'm going to let him do his thing. I might ask for some clarification here or there, but what you're going to see is laying out when it's split screen like this, you're going to see the HB 2827 on the left, or, the left of your screen. And then you're going to see the notice, right? That Assemble Illinois put together, Joe in particular, put together. And he's going to walk you through and show you how these principles are playing out and what is so wrong about the act. I was just sharing with Joe before we jumped in here that I constantly am hearing, well, what's so bad about, right? Well, we're going to tell you what's so bad about it. Fundamentally, what's so bad about it, right? Well, what's so bad about just, so that the government can keep tabs on all children, right? No, that's not okay. And we're going to help you see how this act is unconstitutional.
Right.
And just foundationally, completely it's not even something that they can do,
Nope.
right? They can't do it, right, Joe? So I'm gonna kind of let you take it from there and kind of,
Sure.
Go side by side and talk to people about this and what's so critical.
Yeah, and just to let everybody know that's watching this isn't something that we should even have to do. We're
Right.
going through as a learning
Yes.
point. But
Yes.
really, the people don't need to be lawyers to be able to understand everything, and we don't have to have attorneys. They write the statutes so they are confusing, so the layman can't understand them. And what the goal of this whole series of videos is to show you, and if you watch the presentation video that I put together for the notice itself, it said in there right out of that I didn't even need to read the statute to know that it was fundamentally unconstitutional. As long as you know the principles of the Constitution, you don't even have to read the statute. The only reason we're doing this is to show you why.
Correct. And like Joe said, using it as a learning tool here, right? And I think often, just like we told in part one, if you're just watching this one, that's fine too. But like we said in part one, I was joking around a lot too. Like Joe said, you don't need to be a lawyer. But there are words and principles and concepts. Joe spent a couple years really digging in, right? Yeah. Thank goodness, to the correct way. Like I said in part one, my training, there's a lot about that training that has helped me get up to speed a lot quicker, right? But that doesn't mean anything other than I'm sitting there going, oh, wait a minute, I need to relearn that, right? So pros and cons. But here's the thing. This is fundamental, which is what we're always getting down to, right? This is fundamental principles. Like Joe laid out for you, you've got God, you've got maxims of law, which again, just to define, if you didn't watch part one, right, are fundamental and accepted principles. They're unchanging, okay? The Supreme Court even talks about this constantly. I teach this in my mock trial class. So why do they say this is a fundamental right? They use that word very intentionally, specifically. As a matter of fact, they used it with the Second Amendment. That's a huge argument these days. Supreme Court has said, oh, no, no, no. That is a fundamental right to bear arms. Oh, and by the way, not just a well-organized militia, but you and me. It is a fundamental right. What's so important about that? They're trying to say that is not something you can take away, period, done. And so, like Joe said, he didn't even have to read this. Me either. I mean, it comes out and you're like, yeah, no, you're not allowed. Okay, you're not allowed. But having said that, like we talked about in part one, we want you guys to understand the underlying principles and what's going on so that you can educate yourself, but you can more clearly know your rights and stand firm in that. And I know parents are sick and tired of pretty much being told they're insignificant in their children's lives and that they don't know what's best. And it's why I do what I do, because it infuriates me. And it is up to the parents to choose. Do you want a public education or a private education? And I say that by not
sense of the term.
exactly. And that's a broad sense, right? And I'm going to then use that to help kind of launch into this. Yeah. Because we can move through it, but that's the most grounding principle. So go ahead, Joe. Talk about what you've got here.
So on the right side, it's the notice itself. And it starts off with remonstrance by notice. Remonstrance, or if you have some legalese people talking to you, they might say remonstrance. It's a pronunciation. The word, though, it means it's a strong rebuke or an expostulation. And it's usually used like before they're going to, like government's going to enact a measure or something like that, which is so that in the correct sense of the term, that's exactly what we're doing. They're considering this bill and we're giving them a remonstrance or a strong opinion about it to show them why they can't even do it. So in the notice itself, I want to start off with that on the first paragraph, because that just says a mouthful right there that we, the people, don't understand. And it says, I, one of the people, as seen in the Illinois State Constitution, Article 1, Section 5, 6, and 23, which is Republican in form, sui juris, do serve you this remonstrance by notice, so you may provide due care. What we just said there establishes our status, standing, and jurisdiction, which is so supremely important, because normally, like if we say fill out a witness slip or send a letter or send an email, if we don't come with our correct status, standing, and jurisdiction, then it doesn't carry as much weight, because we need to know what our status is as one of the people. And we did that in part one to explain why the people are sovereign. And in a Republican form of government, the people are sovereign. We're separate and independent from government. But we're also the creators of government, which makes us the source of power, which makes us the masters and them the servant. That little paragraph just says all of that stuff right there. And so it's really important to know that when you're speaking this, and when you're writing this, when you're signing this, you are coming to them as the boss. You're coming to them as the king. And collectively, we do that by a broad distribution of this notice, so that every time somebody signs that, it's a king speaking. And that's why we don't do a petition, because the petitions that are nowadays are first of all done statutorily, and they argue statutes and everything. And secondly, they don't necessarily come always in the correct position as one of the people. They're coming as a statutory creation, which would be underneath government. We're getting over the top of government with our notice and with that paragraph right there. So I hope that makes sense.
Yeah. And just to clarify a little bit more, what Joe is saying here, again, there's so much parallel going on. So like Joe said, witness slips. I think that's an important thing, because people have that in their minds, right? That's one of the mobilizing things that we can do. right, to voice our opinion. And that does matter. And the reason they have that, right, and have to make that available is because we are a Republican form of government. Now, the problem is, as Joe just said, they're often not using the correct language.
Nope.
Right? So they might use persons, which is statutory, versus one of the people, capital P, right?
Yeah.
So we won't get into that, but it's important to understand doing the witness slips is fine, is good. Why do you think that one of the tactics they use is they announce a hearing and everybody floods them with their witness slips. And then, oh, whoops, sorry, we need to reschedule the hearing. Guess what happens to all those witness slips?
Wipe them out.
They're gone. It gets wiped out. So they know what they're doing. They understand notice. They understand. So I just want to make 100%. That clear to everyone. This is not some made up, hokey thing. I know there's a lot of stuff floating out there. This is the real deal.
Yep.
And another reason why, go ahead, Joe.
It just cracks me up because exactly what you said. They know they have to listen or hear from the people. So they create this statutory creation called a witness slip that they then control. When they hear enough or don't hear what they want, they just wipe them out.
By the way, it's gone. And we said we can do that. It's like the fox guarding the hen house, right?
And that's why it's important to understand these things, because when we follow form and process of law in this way, they can't just wipe it out.
Exactly.
It's no different than if you call them on the phone. If you talk to them, that's good. That's okay.
Sure.
But there's nothing written down. There's nothing enforceable. There's nothing actionable on that. All it is it's a hearsay conversation that may or may not have taken place. So
exactly. And there's your court. Yep.
And that's why Jesus answered Satan, it is written. It is written. It is written. And that's what we're doing. We are saying it is written.
Exactly. Exactly. So, it's just like in contract law, they don't want to hear anything that's verbalized, parole evidence, because again, that same principle, right? No, you've got something written down. That's what we're looking at. And so now Joe is going to walk us through and see this is where the power comes from and it's written down and you got to follow us. So go ahead, Joe. Keep going.
So if we jump over to the left side real quick, I just want to show everybody, this is our proof and evidence of how things work. Because if you see down there, when an act starts out, it has to start out with be it enacted by the people of the state of Illinois, represented in the General Assembly. Every single statute starts out that way. Why is that? It's because they're announcing that they're borrowing the power of the people. We've granted them some power, and then they're using that source of power to write the statute. Now, the problem for them in this case is that what they're writing is an abuse of power because we didn't grant them the power to do this. But this is just to show everybody we didn't give up our rights to them to be able to then make statutes that go against our rights. That's not how it works. That would be a true democracy. But in a republic, we've given them some power. We've limited it to them. We never lose it ourselves, and we've already reserved those powers. What powers did we reserve? Well, we're going to read about that if we go back over to the right side with the notice. It says, please take notice that the people have granted the government certain powers, but secured their rights in Article 1 of the Bill of Rights of the Illinois Constitution. This Bill of Rights is supreme over legislative powers, ensuring these rights remain protected and inviolable. All other constitutional provisions and laws must respect these rights. The government, created by the people, exists to secure, not infringe upon these rights and liberty. And then we get right down in and we cite our Constitution because that is the fundamental law. When you hear the Supreme Court or anybody talk about original law is the Constitution. That is our original law.
And we got into this, sorry, Joe, to interrupt, so we can move through. If you guys want to really understand even more of that, watch part 1 if you haven't.
Yeah.
Because we got into this much more. Right. So we're just using this by way of helping you to know like where this comes from. But part 1, Joe does, we talk a lot about this. Joe is great, goes into this in a lot of detail for you if you just want to make sure you watch that.
It's really important to understand what that constitutional provision means.
That's right.
And when we take that and we cite it, the legislature built their house on sand. All these statutes and stuff they've built on sand. What we're doing is building upon the rock. And the rock here, in this case, is our Constitution. And
Right.
so that's why we have to keep going back to that. And I think, remind me if I'm wrong here, but didn't we go through the definitions of these words in the last section?
We did. We
So,
did.
For anybody that didn't listen, go back and listen to those. Pause this, read it from here if you want to. But what words mean are very important, and how we express them in our Constitution are very, very important.
And how they've been changed. We talk about that too. Yep. It's super important to understand that. Yep.
And then just to reiterate the maxims of law down there at the bottom of this page, it says liberty is more favored than all things, anything. Well, what are we talking about in this particular notice and in this particular act? We're talking about the private right that we have, the liberty to educate our own children, which is, there are liberty interests. The Supreme Court agrees with us. I'm not going to beat that dead horse anymore. And then another maxim of law, which is actually echoed in Article 23 of our Illinois Constitution, it says a frequent recurrence to fundamental principles and firm adherence to justice, virtue, and original law are indispensably necessary to preserve the blessings of liberty and good government. These, exactly what we're doing is recurring to these fundamental principles. It's the fundamental principle of that the Constitution is the law of the land, not the statutes. If we go over to the right side, at the beginning of this, they just have a little index here that gives you like a synopsis of what the statute's all about. And it creates...
You mean the left side? You mean over here, Joe?
Yeah. Did I say
okay.
Right?
You said. That's okay. I gotcha.
And it says creates the Homeschool Act. So number one, it's telling you right there, they're creating something. All right. Did the creators, the people, give them the power to create this? The short answer is no. We don't have to read the rest of it in truth, but we're going to go through and learn what this means. It says it requires the State Board of Education to create a homeschool declaration form to be used by a homeschool administrator to submit information indicating that a child is enrolled a homeschool program to the principal of the public school or the school district that the homeschool child would otherwise attend. What this is they're redefining the people, they're redefining our private right of liberty at the liberty interests of our children, they're redefining all kinds of things. They're having
even within their own statutes.
Yeah. And they're wanting the people to make a homeschool declaration. Well, I've got a hint for everybody. We already made a homeschool declaration. It's our Constitution. Our declaration that says that we're independent and that we have liberty and that government is to protect those liberty interests is our declaration. We need not make another declaration.
Yes. Go ahead.
It's funny how legislators and most people think that we have to have a statute to tell us something. Like the Constitution has been relegated to nothingness in everybody's minds. Like they don't even read it.
That's right.
And
that's right.
It already blocks this whole thing right out of the gate.
And, to add on to that, just so you guys understand, everyone understands, our Supreme Court interpreted this right already by saying back in 1950 and said in People v. Levison that if you homeschool, you are a private educator. It's private education, period. There's no such thing as homeschooling, right? That's why the word homeschool, they had to create this to try to create this homeschool, right? And I've always not liked saying that. We say it just to make it understood, right?
Yep.
No, we're privately educating. So my kids, when they graduated from Crown Academy, Jesus the King, right? So they graduated from Crown Academy, and they would tell people, and when they got older, they loved to say, oh yeah, I was homeschooled, because everybody's thinking, right? It's a fact. Private education, our Supreme Court knows that. It's why they interpreted it correctly.
Yep.
Right? And so please keep that in mind. That is a law on the books in terms of common law and interpreting, which is what courts do, interpreting the Constitution, and there you go.
And, again, it gets back to a huge biblical principle to understand, is that this is why I call things like this satanic, because it's Satan's tactic to always rename.
Yes.
Adam in the beginning was given dominion and authority to name all of the animals and all of that stuff that he was given dominion over. And then what he called it, it became. And then you see this principle take place with, like, say, Shadrach, Meshach, and Abednego. That's actually the Babylonian names that were given to them. They had original Hebrew names. And so Satan always wants to rename us.
Yes.
And so he's trying to use statute to rename the people who are sovereign under God into homeschool administrator and all of these different statutory terms, because what they're trying to do is create bills of attainder for everybody. And I'm not going to get into all that right now, but that's the ultimate point, right? Is that they're trying to bring you into a statutory position so that it takes you out of your rightful place in the Constitution, puts you under statute, and then they can presume your guilt instead of presuming your innocence.
And they start from that place, which is against due process of law, which a lot of you've heard that phrase or know what that is, right? It's another right that has afforded us a fundamental right of due process in order, and this is all part of it, being put on notice, right? Mm-hmm. And following that. Yeah. So understand also that what Joe is talking about here, being brought into statutory, right? It's like when you contract with someone, you choose to contract. So their whole goal is to get you to agree and agree and agree and agree. And so now you're agreeing to it. You're kind of contracting, right, mm-hmm. with them and agreeing. And so we want everyone to understand you don't have to agree. You have fundamental rights.
Mm-hmm. And the next sentence of this tells you exactly what I was saying. It says, it provides that a student enrolled in a homeschool program in which the homeschool administrator has not notified the public school or school district with the homeschool declaration form is considered truant with penalties applying. Where was your record? Where was you proceeding according to the forms of law with due process, a trial by jury, all of that stuff? They're considering you truant. So they're already labeling that. They're relabeling the people. They're doing that. And they're telling you in this little synopsis that's not even part of the law exactly what they're doing.
Exactly. Yep. All right.
Moving down from there, and we talked about the being enacted by the people. So they're borrowing our power. And then in section 5 there, it says towards the bottom, it says application. Nothing in this act applies to non-home-based, non-public schools, including but not limited to those that are registered or recognized under this section of the school code. Well, what does that mean? What is that saying? Now, first of all, they're telling you right there that they're creating classes of people, which you can't do. And it says that nothing applies to non-home-based, non-public schools, including but not limited to those that are registered or recognized under this section. What are they saying? They're saying that this act doesn't apply to public schools, and they create this thing called non-home-based and non-public schools. So then where does the regular street language of private school come in here? We've talked about that in the previous one, where what is a private school? Truly a private school, in common street language, you would think like, oh, the Christian Academy down the street.
Yep.
No, they're a public school that is not publicly funded, but they're still statutorily created. Versus what you have in your home, when you educate your children at home, that is not a non-home based, and it's not a non-public school. So they're really segregating the people, in this day and age where we're supposed to be inclusive of everybody, and here they are dividing everything out.
Yes. And to add on to that, it's very clear, again, what we've been telling you guys is that when you say private school or private education, why do you think it doesn't appear anywhere in here? Because again, they know when you say private education, the Supreme Court in Illinois said, yes, this is privately educating children when you homeschool, right?
Yeah,
And
so they know
so it's
exactly what they're doing.
they already know exactly. That's why it's called non-public schools. Okay. And you'll see later, we'll get to it down the road, but this non-public schools is how they have to phrase it. Well, we are a non-public school, period, right? Supreme Court said that. Non-public means, again, that everything they then instruct any non-public, the Christian school down the street, I'll just kind of throw this out there. It isn't necessarily statutory, right? Because it's non-public. So families can get together and create their own school, and they create what everybody loves to call a private school. Okay.
It's all about the creation, and that's something that
exactly
the people need to begin to start to learn some of these things when you do like voluntary associations and things like that.
Which is another video we're going to do.
Yeah, right. They're non-statutory create. So you don't go to the state getting permission and a license from them to create something that you can already do yourself. You can if you want, but
you can if you want to, and pretty much everybody does.
Mm-hmm.
And then the next step is what Joe was just pointing out here, which is really important to understand. I've been explaining this to people since COVID hit, right? So they know that they can't get rid of this right to privately educate. So what are they going to do? They're going to provide a voluntary, up until this act, by the way, intent, a voluntary opportunity. Again, you're going to contract, right? You're going to say, oh, I'm willing to do this and to put you under my thumb. And that is what they mean by registered or recognized. That is currently a voluntary opportunity, is the way they would put it, right? To now kind of be under our thumb in exchange for, and parents, you got to hear this because I have sports kids. They get you with the sports. They say, hey, no big deal, but you know what? Sorry, you can't play any IHSA schools unless you're registered or recognized. And they changed that when my youngest was in junior high, was a junior in high school. And we all went, okay, here we go. Because prior to that, our baseball team, which is very good, we filled out our schedule playing private schools and playing even public schools in scrimmages for them. But it was part of our, guess what? Next year, start calling, sorry, we can't. We will be kicked out if we even scrimmage any non-IHSA approved, right? So I'm throwing this out for practical things that you guys need to understand and pay attention to. This is exactly cracking non-public and why they have to voluntarily provide this opportunity.
Yep. The whole goal of an evil legislature is to drag you into their jurisdiction so they can gain jurisdiction over you.
That's exactly right. With your approval.
Push up against.
Yep. And you're approving it. Okay. You ready for the next screen?
Let's go.
Okay. There we go.
So in this section, we have the Illinois Constitution, Article 10, Section 1, that establishes public schools for Illinois.
And we talk more about this, sorry, Joe, in our first one. We talk a lot about this. Okay.
Yep. And we just need to hit the highlights of this here so that people understand the difference between public and private. Those are two terms that are just fundamental in our understanding about what government can and can't do, what we've authorized them to do. And it says a fundamental goal of the people, that's us, of the state, is the educational development of all persons to the limits of their capacities. I think we all agree about that. Like, that's a good thing. We want, if I choose to do private education in my home, that's fine, but maybe not everybody chooses to do that. So we provide public schools. That's a fundamental goal. That's not a bad thing. It says the state shall provide for an efficient system of high quality public educational institutions and services. I think we could all agree that they're lying to us if they're telling us that we have an efficient and quality public educational system, but that's besides the point. Education in public schools through the secondary level shall be free. There may be such other free education as the General Assembly provides by law. The state has the primary responsibility for financing the system of public education. This is the line in the sand that we already drew. We drew it in our Constitution. We first established our Bill of Rights, which are established before we even create the Constitution. And that's when we talk about even the Constitution has to be in pursuant with the Constitution. So statutes have to be pursuant to the Constitution, and that means follow along. But also, you have to be able to interpret the Constitution and follow along. If this section of granted power that we gave to the legislature, if we don't understand that first, we created our Bill of Rights. First, we carved out, and put a wall up to our private liberty interests, which includes educating our own children in our homes. And then after that, we created public school. We make public school available to everyone, but no one is compelled to go to public school. So then they don't have any jurisdiction. So then what do? They try to relabel you as a homeschool to drag you into their jurisdiction, and we just can't let it happen.
That's exactly right. Okay. This is now, again, we're going back to show this very important point. This is now going back to the act itself.
Yeah, and this is actually quite a ways down in the act, and that's where
Correct.
they like to bury stuff. We just figured we'd pull it out and show everyone here. It says,
and real quick, this is also in the section that is amending other acts.
Mm-hmm. So it says registration and recognition of non-public elementary and secondary schools. So first of all, the word registration and non-public should come to your attention very quickly and say, the first thing that we have to ask ourselves is, are we subject to this? Well, if you know who you are as one of the people and you know what your Bill of Rights says, then you can say, oh, it's not talking about me, because I don't have to register and I'm not a non-public school. No problem. And it says the findings, the General Assembly finds and declares that the Constitution of the state of Illinois provides that fundamental goal of the people of the state is educational development of all persons to the limits of their capacities. Hey, that's cool. Perfect. Good job. They cited the Constitution to show where they were granted authority to do what they're going to do. But then they had this little word called and it says, and that the educational development of every school student serves the public purposes of the state. Now, wait a minute. Where does it say that in the Constitution? It doesn't. And secondly, why are they saying that? They're saying that because, as we said in video 1, that we've heard it's a republic, not a reprivate, because they only have jurisdiction in the public realm. And what they're trying to do is to say that every school student, meaning all children, serve the public purposes of the state. Well, I've got news for the state. I did not have children so that they could serve the state. We have children so they can serve the Lord, and then the state is supposed to serve them. So let's not get things flipped around. And again, this goes back to a biblical principle, because what does God's word say? It says it in Deuteronomy 4 and Revelation, 22. Do not add or take away from the words of this book. Do not add or take away from my commandments. Our Constitution is the commandment of the people to our servants. They can't add to or take away. And what they're trying to do right here is add to give context to what we meant by the fundamental goal of the people of the state is to provide educational development. And they're trying to add context to get their foot in the door to gain jurisdiction.
And redefine again. Remember what Joe was saying, right? It's all about that redefinition of terms and what we believe to be true, right?
So then, as as you pointed out earlier, then they tell you right out of the gate, this is going to be a voluntary registration and recognition of non-public elementary and secondary schools. It's voluntary. Go ahead, we can do it. It's voluntary. It's fine. Everything will be fine. Oh, wait a minute. Let's read Part B. All non-public and elementary schools may voluntarily register. However, beginning August 1st, 2026, all non-public elementary and secondary schools of the state of Illinois shall register. So they start off with this voluntary compliance, and you do it, and then you just have to keep doing it. And all of a sudden now it's no longer voluntary, but it's mandatory. And it's just the frog in the kettle type of thing. They try to get us dumbed down to this stuff, so we just keep doing it when we have a duty and obligation to recur to the fundamental principles. Like, that's one of the things that God has put on us. And I've said this before in other talks and stuff that I've done. We really have to take a cold, hard look at ourselves as the people, because we have to be honest and say, you know what? We've gotten lazy, we got uneducated, we didn't know this stuff. And God's word says, my people perish for lack of knowledge. And we all know that one. And we've lacked knowledge. But they don't read the second part of that verse where it says, and they reject it.
Exactly.
We're coming into this time where we have all this oppression and tyranny and stuff coming from the state, and they're trying to invade our homes. And what we have to recognize is, okay, we might have been lacking knowledge, but now we go and we get knowledge, and things like this are being shared with everybody. We have to be careful that we don't reject it, because it is our duty and obligation. It's an assignment from God that we actually control our state, not the other way around.
Correct. All right, here we go.
No, we were going to hit that one twice, but I don't think we need to now.
I don't think we need to. I think we covered it well.
So the next part of the notice, it says, please take notice that the people are guaranteed that the state of Illinois is a Republican form of government. Absolute and arbitrary power over lives. Now, understand when this is written, this is actually what we're quoting here is a constitutional provision directly out of the Kentucky Constitution in the Bill of Rights. Absolute and arbitrary power over the lives, liberty, and property of freemen exists nowhere in a republic, not even in the largest majority. Again, that says a mouthful when you understand that we're not a democracy. That's what they try to relabel us out of being a republic, because Satan likes a democracy, because then all he has to do is change the moral compass of a majority of the people, and things go south. But in a republic, I don't care if 99.9% of the people disagree with me. If it has to do with my rights, I retain those. I have those. Nothing can change about that.
That's right.
The people are sovereign and have only granted limited power to their representatives. That is such a strong statement we have to understand. We only grant limited power to our representatives. And then Article 4, Section 4 guarantees that every state in the Union is a Republican form of government. And then the definition there, which I think we went over this in the last videos as well, but just to reiterate,
we did.
In a Republican form, the powers of sovereignty are vested in the people and are exercised by the people either directly or through their representatives chosen by the people, to whom the powers are specially delegated. So we gave them limited powers and we gave them specially designated. That doesn't mean they have special superpowers. That means they're specially, intricately placed in there of what they can and can't do.
Right. And in part 1, Joe and I covered and talked about also in the United States Constitution Bill of Rights, you've got Amendment 10, which I always say is one of the least known and most powerful, because it lays out very clearly, very directly, that Congress has been delegated very specific powers, and whatever has not been delegated to Congress and laid out, by the way, in Article 1, Section 8, it's very clear the areas and what Congress, the American United States Congress, can cover. Amendment 10 says, if it hasn't been specifically delegated to Congress, the power is retained by the state and the people. respectively. Okay. So again, it's that dual sovereignty and that understanding of the fundamental right of the people, weak and limited, like Joe was talking about here. We cover that even more in part 1.
Amen.
Okay, so moving on, and like we were saying, if you guys want more explanation, understanding of that, definitely go back and watch part 1. We're breaking it up into some bite-sized pieces, or also the whole thing. So moving on, this is important. Go ahead, Joe.
So the next part that they give you is their findings, or like this is like our excuse for why we're writing this, is what it could be said as. It says the
Exactly.
General Assembly makes all the following findings. There are a number of children participating in homeschool programs in the state, and homeschooling is currently the fastest growing form of education in the United States. Well, why is that, folks? It's because our public education system is broken, and it's driving people away from it. But they can't have that because this is all a money-based thing. And the more children that come out of public school, they don't get as much money, and then that becomes problematic because they can't indoctrinate the kids the way that they want them indoctrinated.
That's right.
But here it says the highlighted part. The true number of homeschooled children is likely to remain unknown without adequate notification and oversight. There's no responsibility that we've placed on government to know this number. There's no granted authority that we've given them as to what they have to do to provide this number. The entire premise there is just a made-up thing of them trying to create an excuse to exert power that they don't have.
Yep.
And then getting into part 2 there, it says the laws of this state do not adequately protect homeschooled children in situations when notification of the type of schooling of the child would help reduce vulnerabilities to abuse and neglect. Now, here again, first of all, they have these terms, abuse and neglect, that they try to use, where they use those in statutes to presume guilt, and then you have to prove your innocence.
That's right.
And that's the flip of what it's supposed to be. The other thing there is that what laws don't adequately protect children from abuse and neglect? The common law protects everybody from abuse and neglect. And so we don't have to create a statutory scheme to come up with enforceable statutes to protect children. All we have to do is use the common law. The common law already doesn't allow you to abuse or neglect a child. All you need is an affidavit from somebody that has firsthand witness and is willing to swear to it. And then you can take them through a common law process known as a trial by jury to make sure that the children are protected. The next part here, we just got to spend a second here to really understand this. It says the notification of and requirement for homeschooling are in the best interest of the children. That statement there, the best interest of the children, is such an abused thing by government because they take it upon themselves that they're the arbiters of what the best interest of children are. Now, first of all, each individual parent is the one that makes up the decision for what is the best interest of the child in the common sense of the word. Secondly, the state does have a duty to do what's best for the interest of children when it comes to children that are under the state's care, according to the Constitution. Meaning, if you have a child that both of their parents have died and now they're a ward of the state, or both of the parents are lawfully incarcerated and the state has taken over care of the child, then they do have the duty to serve the best interests of the children as if they were the parents.
Right. They become the de facto guardian.
Right. But you don't get to just assign yourself guardianship over my children just because you're the state. That doesn't work like that. The second thing is to understand the legal use of the word interest. Because you think of it like a property. If you have interest in a property, like if you and I both own property together, we both have an equal interest in the property. If I own property exclusively and you're not a part owner in it, then you have no interest in the property. And that's where we get into things like equity. to bring equitable solutions to problems and stuff. The moment that the state is trying to say that they have an interest in your child, they're trying to co-parent with you. They're trying to be mother and father with you. And we never granted them the authority to do that. And that's why they're doing it. You got to understand why they're doing that. It's because it's a legal term to where they're gaining jurisdiction by claiming ownership to something that they have no right to. And that one probably irritates me the most, because my wife and myself are the parents with 100% ownership of our children. With
100% interest. And I got to say,
we don't share.
Yeah. We don't share. I'm sorry. I'm laughing. I didn't mean to interrupt you. Because and any mama bear who's watching this right now, Joe, is like, oh yeah, no, don't even try to tell me you've got one iota of interest after all the labor and everything I went through, right? I'm just laughing because, that comes up. But I have to say, this has been my Aspires, my company's kind of sticker logo since when I got started, if you'll see here. And I did this 4 or 5 years ago, right? Yeah. So I'm with you on that. I love that. I don't co-parent. I mean, I did that very intentionally.
Yeah, that's
and I do see it now.
Coined phrase, but it lawfully means everything.
Everything.
That's the argument right there.
Yep, absolutely. And I love that.
For the parents that do send their children to public schools out there,
great.
That doesn't mean that you lose interest in your children and that you still retain your rights. We're specifically speaking about the Homeschool Act. So don't think that just because you send your children to school that you lost interest or gave that up to the state. Absolutely not.
Never. And if you ever have gone through something, I do what I do, and I just want to throw this out there to parents to mirror that. Literally, do not ever feel you are trapped. They try to make you feel like you have no option, no choice. That is why I do what I do. I know God's called me to it is the main reason I do what I do. But I'm telling you, to me, if you choose as a parent to send your child to public school, that's wonderful. That's fine. That's your choice. But what really gets me, and what Joe's speaking to here, is do not let them make you believe you are not the experts when it comes to your child. And beyond that, that you lose your rights, like Joe said, and never feel like you're trapped. That is, I just want to emphasize that, because I hear that and people get very worried, right? That they're going to make them upset, or that they don't have the right to do this or the right to say something when something has been issued against their child. I mean, I'm sorry, even detention. I've heard parents say that, oh, well, they have to fight. It's a school rule. No, if you believe your child doesn't belong in there, or you as a parent are like, hey, we're going to do this. It's the same thing like with attendance, right? And I got to share this because it impacted me as a kid. I guess I get this too, because my parents understood this to their core. And I remember standing in the office and my mom standing there with the woman, she was signing me out, and she came to surprise me to take me to the Smithsonian because I loved Monet, and they had a special Monet exhibit. My mom goes in there and they're giving her a hard time, saying, well, where are you going? Why are you taking her? She goes, it's none of your business. I'm her mother and I'm taking her out of school. Yeah. She wouldn't give him anything because she's like, stop. You have no right to say anything.
Yep.
It imprints. Remember that, because I hear parents all the time, well, I can't take him out of school. Yes, you can if you want to.
Yep.
Anyway, go ahead.
Yeah.
Moving on.
Well, that's it. Point number 4.
This is important.
Public schools are encouraged to the best of their ability to offer their programming to homeschooled children, to homeschooled students and family, and to have open communication with homeschool families. Public school can offer their programming all they want, but if we don't want it, and rightfully so, like, you have to just see how these are worded. Because we're the people and we provide the public schools, we absolutely have access to all of the programming there if we would say I wanted to educate my child at home, but use the exact same curriculum, then I have access to that because I'm one of the people. But
Right.
I also am not required to use that programming, which I love the language that they have there. Because they tell you exactly what they're doing.
That's right. I love it. I love it. All right.
And then here's the next part that whenever, if you are ever reading something, whether it's the Constitution or a statute, you always have to first, before you even read it for context, you have to go and read the definitions, because the definitions tell you everything about what you're reading. And
Right.
you can't even, it's like a foreign language if you don't read the definitions.
Right.
So in the definitions here, we're going to point out how they're trying to relabel and rename everything that's in our Constitution. Starting off with educational portfolio, means a set of records and materials that document
Sorry.
a child's educational progress during the preceding school year, otherwise known as papers. All right. These are your papers. Now, you have papers in your home. They're secured in the Constitution. They can't just rename your papers to educational portfolio to give themselves access to your papers.
That's right.
The next one is homeschool administrator, means the parent or guardian of a child or another member of the household, or anyone who may exercise legal custody over a child, defined in this section, who is responsible for the provision of homeschool program. What did they just try to do there? They just tried to rename the people and the parents as homeschool administrator. They just gave you a title that's statutory to then try to make you subject to their jurisdiction. They can't do that. They can't do it. They just can't. Like, I don't know how else to be more clear with people. Like, they literally can't write or enforce. They literally can't vote on this thing. Anytime they vote on it, they're already breaching the trust of the Constitution.
That's right.
Homeschool declaration form means a template form created by the State Board of Education to be used by the homeschool administrator to verify the child is enrolled in a homeschool program. Again, we don't have to create a declaration form. We created what's called the Bill of Rights, which already declared our freedom and independence and liberty to do this. So we don't have to rewrite anything. We don't have to come up with a statute. We just enforce the Constitution, stand on the Constitution, and it tells us everything that we need to know. Homeschool program means a non-public school consisting of the children not more than one household. So there, they try to relabel your home, your house, and your family as a homeschool program, as if they have some sort of jurisdiction over that. They don't. Just because they create a new name for something and call it something different doesn't mean you lose your rights secured in the Constitution.
That's right. And Joe didn't highlight this because he just talked about it, but I want to point out that they literally call you a homeschool administrator in the next line.
Yeah.
Right?
Yep.
We're a homeschool administrator.
Yeah.
Now you're not a parent. You're a homeschool administrator according to their statute and definition. They even say it right there, right? For providing a course of instruction. Oh, by the way, also be aware of words like sufficient to satisfy the education requirements set forth. Satisfy who? Satisfy, I mean, be aware of the audacity.
That's the working of the line that we read out of the Kentucky Constitution that says arbitrary power over one's life. They're just creating arbitrary power, creating arbitrary standards that they think are right.
Right. And it is not even an elected official. We're talking somebody, a superintendent or a principal, as we know, if you read more of the act, right, can literally just be like, you know what, I don't agree with that curriculum because it doesn't follow Common Core, which we all know is garbage. But they can now come in and say to the homeschool administrator, not a parent, the homeschool administrator, right, that this isn't satisfying it. So don't, when you hear like it's innocuous, what's the big deal? Huge deal.
Huge deal.
Huge deal. So now back to the notice, which correlates.
Back to the notice. one of the things that was put into the notice was an excerpt from Troxel v. Granville, which is a Supreme Court case back from 2000 where Sandra Day O'Connor wrote the opinion. And one of the reasons that this one was chosen is because they very clearly point out the liberty interests of the parents and everything. And it also cites many other cases, which shows the repetitive nature of the Supreme Court stating very firmly and solidly on this principle. But before we get there, it says, please take notice it has been a long-held historical precedent that children are the fundamental liberty interests of their parents and the fundamental rights of parents to make decisions concerning the care, custody, control of their children is protected by due process. Again, that says a mouthful right there. It's basically restating what's already in the case there. It says the people shall not be deprived of their liberty interests without due process of law. This liberty interest includes the right to direct the upbringing and education of children under their control and is protected not only by the Illinois Constitution, but also the United States Constitution and cannot be interfered with by any legislation. And you can pause and read all of this on your own time, but it very clearly says here in this excerpt that, first of all, that no state shall deprive any person of life, liberty, or property without due process. We're going to get more into explaining what due process is a little bit later, but don't forget that part, that all states must give due process of law, and it has to be according to the Constitution. They go on to say that that our Constitution provides heightened protection against government interference with certain fundamental rights and liberty interests. The liberty interest at issue in this case, the interest of parents to the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interests recognized by this court. Like, our state legislature couldn't be more off base on what they're doing here. And this thing gets steamrolled to the Supreme Court. But this is why we have to learn how to do these notices, because there's going to come a day very soon, I believe, where right now our state legislature just says, oh, we're going to write this.
And we're going to do what we want.
We're going to see if it sticks.
Yep.
And then, oh, if it gets shot down in court later on, no problem. No problem.
Exactly, because it takes money and you have to be able to find somebody to take the case. Yep. Right. Keep going.
What they're going to be finding out, though, is that a lot of the people have been learning the fundamental principles of law. And a lot of the people have enjoyed teaching their children about some of these fundamental principles of law. And a lot of the people are learning that we can actually hold them legally accountable for even passing these statutes, because the moment that they pass one, they've already trespassed. And then if they go to enforce something, anybody who was involved in enforcement of that, the key to it can be held accountable. The key to that is that we're notifying them ahead of time. That's why we're sending them a notice. We're telling them, hey, just so you know, we're good people. We don't want you to do bad. We want you to do right. We've already expressed our rights in the Constitution. We want you to do right and abide by that. That's right. What this notice is telling them. This is a note to them to say, hey, you're making a mistake. Yes. Now they have a chance to not pass this.
And I think that's a huge point, Joe, both biblically, like we've been talking about, and so critical to understand. We're sharing this with you not to make this contentious. We're sharing this with you understanding that there are very good people wanting to do right and wanting to do well by their fellow, constituents, or their constituents and their fellow man, right? We're not saying, oh, everybody in the legislature is evil, right? What we're trying to say is exactly what Joe was just getting to. This is, hey, this isn't okay. This is why it's not okay. And we were letting you know that so that you can do the right thing. Oh, and by the way, if you don't do the right thing, that comes in part 2 or part 4, right? But it is important because you are starting out by just saying, hey, you probably weren't aware. So just in case you weren't aware, this is not okay.
Yep.
But it doesn't have to be in the mindset of anger or contention. As much as we all parents who get this are frustrated and upset, coming to this in such a way as to say, hey, you had a public school education just like I did, and boy, we didn't learn these things. So let's understand that.
Yep. So they go on to say, we held that the liberty protected by the Due Process Clause includes the right of parents to, quote, establish a home and bring up the children, and to, quote, to control the education of their own. And it goes on. You just pause this and read this, because then they go on to say that the child is not the mere creature of the state, which would mean a statutory creature, which means the moment they try to label your child as homeschooled child, is they're trying to create a statute. They're trying to make them a creature of the state, which would then be something that they have authority over. You wouldn't any sooner just walk into the store with your child and have some dude come up to you and call them by a different name and say, well, that's my child. His name's Billy. Well, no, his name's Timmy and he's my child. Like, you wouldn't just hand him over. So why would we allow the state to come in and just to call your child by a different name and then take them and do what they want with them? Because that's where this is all heading. It's not conspiracy theory. They already use DCFS to unlawfully take children from people all the time.
All the time.
If you think for a second that they're not going to take this thing that seems innocuous and then just add to it a little bit, or use it to enforce a truancy hearing or something like that, to use DCFS to take your child, that's exactly what they're trying to do.
It's exactly it. And we're going to talk about that more when we get to the truancy, like you said, with due process. And literally just think about this. Not filing a piece of paper with an administrator can immediately trigger your child being taken from you.
They presume your guilt immediately.
Immediately. It's ridiculous.
Go back real quick to that last one.
Yep.
On the very last highlighted section, says
this is citing another case.
The primary function and freedom include the preparation for obligations the state can neither supply nor hinder.
Yep.
When we are training up our children, we're training them up to be able to provide obligations to the state if they want to be a public servant or something like that. The state can't come in and say, well, we have to educate your children so that we make sure that we run a very orderly state. The state can neither supply nor hinder that. So we just have to make sure that we understand what all these things mean, because they're trying to gain interest into your child. They're trying to gain interest in by saying, well, we have an interest so that we can run the state. We've got to have people that know how to do that, or that know how to abide by the laws. That's why they like to call people law-abiding citizens. I like to call them law-making people, but
I like that. So we all need to say that again. Okay. This is still continuing the notice. And let me pause it right there real quick, just to reiterate that we talked about in part 1. The goal of this, there is this notice, right, to put them on, that everyone, every parent, everyone can sign. And it's at assembleillinois.com, right?
.com/forms.
/forms is exactly where it is. Yes. And but don't worry, because we're gonna have the link. You'll have the link in here.
In case people are listening, it's assembleil.com /.
Oh yes, sorry. Sorry about that. But like I said, we're gonna have the link for you directly, so you can go and sign this notice. And huge. It's kind of like signing that witness slip on steroids. Like, it literally does something, right? And that's why, Joe is explaining what's going on in here. But I just want to throw that out again to have people, you guys, this is huge. Sign this. Like Joe said earlier, I look at this as we're kind of battling on two fronts right now. As people are understanding and bringing people up to speed, which is the thing we need to be doing the most of. But at the same time, we're trying to battle for our current living situation, right? So like Joe said earlier, it's not a bad thing to be calling and making your position known right? And we're still going to do everything we can to defeat this ridiculous legislation, right?
Mhm.
So we're not trying to say the notice is the only thing you should be doing. That's not what we're trying to tell everybody. But this truly is where you should be going first and making this a priority and sharing this out to people and hopefully just spreading these videos, please, to all parents. I mean, I don't even care if they don't live in Illinois, send it, because people have to understand this with respect to everything. And I don't know about you, Joe, but as parents, I know my husband and I, when it comes to our kids, we're going to sit up and pay attention real fast.
Yeah, I'll put
And
up
we're
with a
going to put
lot
the
until you
time in.
mess with them.
Right.
Yep.
Look at COVID. Look at shutting down and masking, I mean, yeah, exactly. Okay. So having said that, let's keep going. This is part of the notice still.
Yeah, and again, let's not belabor all of this, but please
Right.
stop and read this because it goes through. It says, we've recognized on numerous occasions the relationship between a parent and child is constitutionally protected. It's not statutorily protected. It's constitutionally protected.
That's right.
It goes on at the very end of it with the findings that says that it unconstitutionally infringes on the fundamental right, parental right. We have fundamental, that's basic. These are basic things that we've gone so far from instructing our government and making them obey that they've now become these unruly servants that think that they just have rule of the roost and can do whatever they want.
Correct.
And Jesus speaks about this in his parables about these unrighteous servants and stuff. And we, the people, need to become the masters again, where we come in and we correct these errors that they're doing.
Amen. So true. All right. Moving now back to this is still the notice, but an important things. If you'll understand, Joe's also walking you through this process of pointing out, right? Principle, constitution, the maxim of law, and support of that, right? So again, here's the next one.
And you'll see this pattern if you've ever seen any of the other notices that get put out. We don't ever quote statute.
Right.
Because we're dealing with the Bible, then the maxims, then the Constitution. We don't need to quote statute because the statute has to fall in line with that. We always want to stand in our status and standing as one of the people. And in our Constitution, we have an outline for them. No person shall be deprived of life, liberty, or property without due process of law, nor be denied equal protection of the laws.
That's right.
A maxim of law says, no free man shall be deprived of life, liberty, or property, but by the lawful judgment of his peers, or by the law of the land, that is, by the common law. These things here mean something. These words mean something. And first of all, we've identified in this case what we're talking about our liberty. Our children are our liberty interests, which means we can't be deprived of our liberty interests without due process of law. What is due process of law? Due process of law involves, in one part, the lawful judgment of our peers, i.e., a trial by jury, or by the law of the land, that is the common law. The Bill of Rights sections of our constitutions are the common law of the land.
Right.
They've tried to make us think that common law is something different than that, and it's not. That is the common law. It's available to everybody. And if they want you to fill out a homeschool declaration and they're going to say that your child is truant if you haven't done that, they just think of it this way. They literally cannot do that without a trial by jury. They literally cannot do that without a trial by jury. Everybody involved in that, if they try to do something to you because of that, if they do it without a trial by jury, among other things which we're going to discuss, but if they do that without a trial by jury, 100% unconstitutional, and every single person that took part in that has
liability,
breached the trust, has liability, can be personally held accountable, all of these things that go into that.
That's exactly right.
The next thing here is we cite Miranda versus Arizona, where this is a huge sentence to understand. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation that would abrogate them. Remember, we explained before in part one that common law is distinctly different from legislation. Legislation is rules for statutory creatures. The people and their children are not statutory creatures. We are part of the common law. We are the creators of the Constitution. We're not subject to them. Government is subject to that. We are not.
Right.
And they can't make rules that would abrogate our rights. The next part says, please take notice that government cannot bypass constitutional mandates by relabeling or reorganizing. Indirect violations are as unlawful as direct ones. That is not the words of us. That's actually the words of Justice Gorsuch in the SEC versus Jakarski case.
Yep.
And he openly said this in the oral arguments of the case, because that's what government has been doing for a long, long time, is they've been relabeling and reorganizing. And then just like indirect violations are as unlawful as direct ones, what they're doing with this is the state is writing legislation that's unconstitutional. They know they can't enforce it. So what they're doing is they're getting the school principals or superintendents to try and enforce it. They're getting truancy officers to enforce it. They're getting other people to enforce their unconstitutional laws. And what Justice Gorsuch said is that just by them shifting the responsibility for enforcement to someone else doesn't make them released from the liability.
Any less responsible. Yeah.
Yep. Says the rights of people over children's education are protected from government overreach. The Illinois Constitution allows regulation of public schools, but does not override the secured rights in Article 1, Section 1. The free people of Illinois cannot be forced into the public realm of education or have their private liberty interests regulated without due process. And then we have the due process of law definition in there, which we discussed in part one of this, that it's all based off of the settled maxims of law and the law of the land, which is the common law, which is the Constitution.
That's right. Amen. And again, fundamental rights, that word.